Order. Order. Council will resume the sitting.
And Anguilla Police Amendment Bill 2016-17.
I move the bill entitled the Anguilla Police Amendment Act 2016 be read for a second time. Mr. Speaker, honourable members of this House, let me explain a little bit about this bill in the way that I spoke at reasonable length in relation to the Witness Protection Act, which we looked at this morning. I might pick up on a few comments I made this morning about the nature of the work that the RAPF do to keep those in Anguilla safe from serious criminal offending, because of course not only is their work about investigating and detecting crime, it's also about preventing crime. And sometimes if those who might be minded to commit crime are aware of the powers and law available to the police, those laws themselves have a deterrent effect, and I think people may have touched upon that in their speeches earlier. So we're not just here to pass laws to deal with offences once they've been committed. We are here to try and send out a message to those who might want to commit offences otherwise. And that again is an important message to send out, just as it is important to send out a message to all of those law-abiding, decent people within Anguilla who want to see effective investigation of crime and prosecution of serious criminal offenders. On that note, one of the things that has become apparent to the RAPF through its work investigating serious crime, and I'm particularly thinking of shooting in this context, is their ability to investigate and prosecute these cases as effectively as they might. Their ability to gather sufficient evidence to bring offenders to justice and to prosecute them for the most serious types of crime, often murder, attempted murder, all the kinds of firearms offences as well that are associated with that type of offence. So what tools might there be available to the police, whilst of course balancing the rights under the Constitution to those who are suspected of criminal offence and provide proper safeguards? How might we balance those two competing ideas? Mr. Speaker, in 2015 we first sought to look at amending the Police Act to allow for the taking of non-intimate samples on arrest. Presently, and since 2013, Mr. Speaker, the law has been that the police have been able to take non-intimate samples after they've charged defendants with criminal offences. So that law exists already, the taking of non-intimate samples. But what this amendment seeks to do is, with protections, and I will go through the protections at length because the protections and safeguards are very important, but with proper protection, this would allow the RAPF, the police, to take non-intimate samples from suspects, those who've been arrested with on reasonable suspicion of criminal offending. And we say that's an important step, and it's an important step forward to bring forward the time of being able to take non-intimate samples from charge forward to arrest.
What's the difference between them? Well, obviously one can arrest someone on the grounds of reasonable suspicion of them having committed a criminal offence or being about to commit one. Whereas charging is the decision to initiate prosecution and the sufficient evidence to prosecute. Why is it important that one has the ability to take non-intimate samples on arrest? Well, the point is this. If one can only take non-intimate samples on charge, i.e. after you've got sufficient evidence, then all you're doing is bolstering a case where there already is sufficient evidence. That's important, of course, to get the best evidence as possible. But what it means if you can't take non-intimate samples on arrest is that you may never be able to get the sufficient evidence in the first place in order to charge someone, because the forensic evidence, gunshot residue, DNA, that type of evidence may be the very evidence that you need in order to charge a defendant with a crime. And so what this law would enable is the bringing of prosecutions, the charging and bringing of prosecutions, and hopefully the bringing of defendants to justice when they've committed criminal offences. Equally, again, the flip side is, taking non-intimate samples may result in a person being utterly exonerated and excluded from ever being charged with a criminal offence, because after the results come back, the GSR or the DNA, it may prove that this person definitely wasn't involved. Let me give you just a brief example, because we've had a number of public consultations. I've been on the radio. We first had a version of this bill in 2015. It went back for further amendment because we listened to the types of safeguards that people want. We're going to go through those. But before I get to the types of safeguards we're now looking to build into the law, let me just give you a rough example of what I'm talking about. Say, for example, the police arrive at the scene of a building somewhere and they hear some shots have been fired, and they see 4 individuals run away from the scene, from a building, and they go up into the scene, and in a room they find a man shot dead or a woman shot dead, someone shot dead, and say blood and gunshot residue and a gun even, all these kinds of things at the scene. Now at the moment, those 4 individuals who they saw running from the building, they may have reasonable grounds to suspect they were in some way involved in that commission of that murder, but they don't have sufficient evidence to charge them with that murder. So at the moment, they couldn't go necessarily and take any non-intimate samples from those 4 individual suspects on arresting them. And so they would have to get sufficient evidence otherwise, if there was. And there may not be any other evidence, so they may never be able to prosecute those 4 individuals. Whereas if they can take gunshot residue and non-intimate samples from, and I'll go through what non-intimate samples mean, but if they can take non-intimate samples from those individuals and say those samples matched blood at the scene of the crime, or gunshot residue from the gun on the body, or the like, if those match, then that may be the very evidence that they can enable to prosecute and charge those individuals. Equally, as I say, if they don't match, it may well be evidence that exonerates them. So that's the purpose, and again, it wraps up with everything we were saying this morning about reassuring the public that the police doing everything that they can to investigate serious crime, and giving reassurance that it is worth individuals coming forward to assist the police in giving evidence. So I hope that explains something about the purpose of the bill. But it wouldn't be right if I didn't heavily focus, of course, on safeguards, because a suspect or a defendant have constitutional safeguards under the Constitution, which give them, quite rightly, many protections. And we have to balance in Anguilla the desire to investigate, prosecute serious crime with protecting those rights. Quite rightly, they're enshrined in the Constitution. So, following various consultations and the like, we sought to build in a variety of safeguards. So, they are enshrined in the bill. So, for example, those safeguards will mean that the taking of non-intimate samples following the arrest of suspects would only be, firstly, where there's reasonable cause to suspect them, secondly, of committing arrestable offences, and again, that's defined under the criminal code as offences which carry an imprisonment of 5 years or more. So again, this is only for more serious crimes.
C, that the approval for taking the sample would have to be given by an officer of the rank of inspector or above. E, that samples would be taken at the police station. E, that the grounds for arrest would be recorded in writing and offered for the suspect to sign. F, that the suspect would be given the opportunity to consent in writing to the take of a sample. G, if the suspect refused consent, the magistrate's court would decide whether it should proceed with, the police should proceed with the taking of the sample in the interest of justice. H, that it only applies to non-intimate samples. I, that reasonable force would be allowed to be used in the taking of samples. And J, that if a suspect is not charged or acquitted after charge, the sample and record thereof should be destroyed. So there are a number of protections, but I will go through those now when looking at the bill. Just to point out that these are far greater protections than are available in many jurisdictions. There are similar laws which indeed allow for the taking of intimate samples, and by intimate samples I mean body fluids, such as blood and the like, and they allow for the taking of those intimate samples, and they also allow for them in circumstances where there is no right to go before the magistrate and refuse. So there are a number of protections that we're going to go through when looking at this bill that are simply far greater than there are in other jurisdictions. And of course, that is a result of saying this is what the public in Anguilla would like to see. They'd like to see the utmost protection. And we understand that because, again, there's this balance between making sure we investigate and prosecute serious crime, but also making sure we provide sufficient protections and the police are properly trained and act properly. There's always got to be a balance between the two. And that's what we're seeking to do in the bill, to balance these two competing aims. So if I might then turn to the Anguilla Police Amendment Act 2016 itself. It's an act to amend the Anguilla Police Act to give the police power to take measurements, photographs, fingerprint impressions and non-intimate samples on arrest, as I've already indicated. If I were to, and of course to make sure they're admissible as evidence before the courts. If I go very briefly through the bill, in relation to the clause 2 of the bill, what it does is it sets a series of definitions. One of them is what an arrestable offence means, and I've already indicated that an arrestable offence is defined under the criminal code, an offence that is one that's punishable with 5 years imprisonment or more. It also defines non-intimate samples, because that's something that I've been talking about, and distinguishing non-intimate samples from intimate samples such as body fluids and the like. And non-intimate samples are defined as a footprint or a similar impression of any part of a person's body other than a part of his or her hand. B, a sample taken from a nail or from under a nail. C, a sample of hair other than pubic hair. D, a swab taken from any part of a person's body other than a body orifice. E, a swab taken from the mouth. And F, saliva. And a non-intimate sample, that's the definition of a non-intimate sample. The definition of a photograph includes digital photographs, because we're in the modern age, and the previous act had dealt with photographs, but we want to move to the system where nowadays photographs are electronically and digitally created and stored. So the first section, clause 3 of the bill, inserts section 26A, a new section 26A, and this is the power to take measurements, photographs and fingerprints on arrest, and it allows for a gazetted police officer, and a gazetted police officer, I should say, is defined under other legislation, but it means a superintendent or above, or it allows for any police officer of or below the rank of inspector who's authorised by the Commission to take and record for the purposes of identification, measurements, photographs, fingerprints, impressions of any person when he reasonably suspects them based on information in his possession and the nature or character of the offence for which the person was arrested, that his or her measurements, photographs, and fingerprints impressions are required in the interest of justice for the purpose of investigating, detecting, and prosecuting the offence for which the person was arrested. So, and what it also allows under subclause 2 is any arrested person who refuses to consent should be taken before the magistrate, where the magistrate is satisfied that suspicion of the gazetted or other police officer is reasonable, may make an order authorising the taking of the measurements, etc. And it allows for the use of reasonable force if, under subsection 2, the magistrate is satisfied that it's reasonable
to take the sample. It also, under clause 4, allows for the fact that where any measurement, photograph or impression is taken of a person who has not previously been convicted of any criminal offence, and they're charged with that offence but discharged or acquitted, or they're not charged with the offence for which they've been arrested, then all records relating to the measurements, photograph or impression should be destroyed in the presence of a gazetted police officer within 48 hours of the discharge or acquittal. So again, we're providing safeguards in relation to these measurements, photographs and fingerprints, just as in relation to non-intimate samples. So, and subclause 5 requires that notification is given to the person involved within 7 days of them being destroyed. So that deals firstly with the measurements, photographs and fingerprints. Then clause 5 of the bill inserts new section 27A, which is the non-intimate sample section, which is the one I've been concentrating upon. 27A now allows for it to be lawful for a gazetted police officer, or for any police officer of the rank of inspector, who is authorised in writing by the Commissioner of Police, taking record for the purposes of evidence, non-intimate samples from any person arrested upon reasonable suspicion of being about to commit, in the act of committing or having committed an arrestable offence, when he, that is the police officer, reasonably suspects, based on information in his possession, that the taking of non-intimate samples are required in the interest of justice for the purpose of investigating, detecting and prosecuting the offence for which the person was arrested. So that's the power. What about the safeguards? This subclause 2, before requesting consent to take and record for the purposes of evidence non-intimate samples from any person, that person should be given in writing the grounds for his arrest without warrant and the reason for taking non-intimate sample. You've got to be given that in writing before any non-intimate samples could be taken. Where a person gives consent to the taking of a non-intimate sample, that consent shall be in writing. So again, another safeguard, consent must be in writing. Any arrested person who refuses subclause 4 to consent to the taking of non-intimate samples should be taken before a magistrate. So if you refuse, you have the right to go for a magistrate, where the magistrate is satisfied that the suspicion of the gazetted or other police officer under subsection 1 is reasonable, and that the taking of the non-intimate samples are required in the interest of justice for the purpose of investigating, detecting, and prosecuting the offence for which the person was arrested. You may make an order authorising the taking of the non-intimate samples. Under subclause 5, notwithstanding subsection 4, that's the authorisation of the magistrate, non-intimate samples may be taken for the purposes of subsection 1 from a person under arrest without consent where the person has been charged with an arrestable offence. All that does is really, in effect, build on the existing law. This is where once a person's been charged with an offence as opposed to being arrested, this is the subclause that allows for a non-intimate sample to be taken without consent. Under subclause 6, for the purposes of taking non-intimate samples in accordance with subsection 4 or 5, reasonable force will be used. Under subclause 7, non-intimate samples shall only be taken at a government hospital or health facility or at a police station. So again, there's further protection to make sure that this is done in sanitary and proper conditions and it wouldn't ever be done on the street or at the scene of a crime. Subclause 8, where any non-intimate sample is taken of a person who has not previously been convicted of any criminal offence, and that person is charged with that offence, but discharged or acquitted by a court, or not charged with the offence for which he was arrested, all records relating to the non-intimate sample should be destroyed in the presence of a gazetted police officer or handed over to the person within 48 hours of the discharge or acquittal. So again, we have the safeguard here to make sure that if a person isn't charged having been arrested, or if they are charged and then they're acquitted, the sample is then destroyed. Under subclause 9, where any non-intimate sample is destroyed in the presence of a gazetted police officer, the person should be notified by mail within 7 days that the non-intimate sample has been destroyed. So again, to make sure that the records are there and the record really is destroyed. Section 27B is inserted by virtue of clause 6 of this bill, and that's just to make sure admissibility is evidence, it's entitled, and it makes sure that all these samples and photographs, etc., are admissible in evidence, which is of course important if you go to use them in a prosecution. It states that measurements, photographs, fingerprint impressions, and non-intimate samples obtained under this Act
or admissible events for all courts having jurisdiction in Anguilla. So those are the key contents of the Anguilla Police Amendment Bill 2016 as it now is. I'm extremely grateful to the members of the public and those who comment to radios, those who consulted upon this, and all comments we've received. I do urge this bill upon the Honourable House. I commend it. We have worked considerably since 2015, and we have revised it in a bit like the Justice Protection Act, which is now, of course, the Witness Protection Act. There's been a dialogue, and we say the law is all the better for that dialogue, and of course democracy only works through dialogue. I therefore commend this bill to the House.
Thank you. Yes, and seconded by Member Rosado. I now invite the please declaration pursues of the stand. Contributions?
I notice, Mr. Speaker, that when I stand, that it leaves a flow of input. So I'm going to stop here, hoping that on the other side we're going to have a flow of input. Because, Mr. Speaker, this bill is such an important bill. And it's an important bill, and because our people have thirsted for more information about what it means, how it's impacting their rights, how it impacts the Constitution. We've heard that a lot of the earlier divisions were actually in direct conflict with some of the rights enshrined in the Constitution. And really, there's been a lot of, I believe, a lot of discussion, some quite healthy discussion in the public about this bill. I want to, at this stage, recognize that the Youth Parliament, and I'm very proud of the efforts they took in making sure that there was really a lot of discussion and debate around this provision. And Mr. Speaker, I know that you care a lot about the Youth Parliament, and you've been very instrumental yourself. But this is one piece of legislation where, because that Youth Parliament existed and saw it fit to deal with it, that we've actually had the kind of input that has resulted in revisions that make it more palatable what we have in front of us. And absolutely, Mr. Speaker, the Honorable Attorney General is right when he says that it's about getting that right balance, but it's also about making sure that we're not taking steps, 5 steps forward, my grandparents used to say, and 7 backwards. And it's very important that we don't rush to put in place laws that when they get challenged in our courts, set us back, cost our people money, cost the public purse a lot, cost for foreign lawyers to come in, cost all that, which we, the people, have to bear. But if we get the consultations right, and we put good law on the books, then we know that we're making progress and we're saving. And our Youth Parliament, I think, by taking really what should have been the responsibility of our elected leaders to go to the people and make themselves available in this consultation to absolutely share views and to do it, I think that would have modeled a lot for us. But we have the Youth Parliament, we have a futuristic context. I know that they're listening, and I hope that they're not listening, Mr. Speaker, when the Minister of Education responds to the questions that I ask. I hope that they're not listening to that, because that can be extremely disempowering, and we're interested, that could be incredibly disempowering, and it is empowering, the efforts that you've made for the Youth Parliament to be facilitated, to assist in this highly educative function, which otherwise doesn't get addressed at the level we want in Anguilla. So I want to say to the AG as well, just like I did before, by going through the sections, by going through the objects and reasons, by dealing with the issues that the public have highlighted, by showing humility and making the changes to make the end product not only more acceptable to the whole, but really cognizant of the common good. That's a good thing, and we need more of our leaders to be modeling that. I wanted to say, Mr. Speaker, a little bit about the futuristic context, because if we don't project not just what our needs are today, but if we don't project in the context of the aspirations of our people, how we're going to be ready to make that step into the future, then I think we're failing our people as well. And this law, it's hard for witnesses, for victims, for their families to see that our law doesn't support them in a desire to create a just society. They see, just like one of the members said earlier, they see bullies absolutely utilizing the law, criminals utilizing the law, and demonstrating on a daily basis that they are above the law. Children have seen their loved ones shot down in a public forum, knowing that it's unlikely that the police are going to have the powers to take the necessary evidence that will allow for a closure and a good result at the end of the day. So I think that this law, it's in our context, far-reaching. I think that it is a good law, and I think that it is necessary in delivering a virtually crime-free society, that we empower the police to do their job, but also give our citizens the satisfaction of knowing that the law will absolutely work to their advantage and not always work against the delivery of justice, which many people feel in our society at this time. Mr. Speaker, I wanted to share, because I think that it's very important. I think that it's important in this context that we appreciate the kind of consultation, the kind of process, the kind of educational process that the Honorable Attorney General has rolled out. I don't want us to take it for granted, because all the time, more often than not, we imagine if we set up a meeting and invite people to come, that they are going to turn out and engage with the laws or the proposed bits of legislation in a very knowledgeable way. That is not the case. But by the efforts of the Youth Parliament, going through those particular provisions, but also bringing in respected experts on the subject to share their views with the public. That is what consultation process is really aimed at delivering. So it's in the outcome. You heard the Honorable Attorney General speak about the revisions, you know, the input of others, you know, the radio, respecting what the public shared on the radio, doing absolutely all that they could to make sure that the public not only understood it, but could buy into the fact that this is a good piece of legislation for us now in our development, but also positioning us, more importantly, positioning us in, you know, to deal with the kinds of challenges we're not only facing now, but that are likely to increase in the future. You heard, Mr. Speaker, when one of the members earlier spoke about the fact that how we are at risk with tourism, and our economic horizon is not encouraging at the minute. It's not encouraging at all. I know families who are suffering, and there are people I know within the sound of my voice thinking, here we are, putting that stuff, putting those laws on the books, dealing with this, but how many of us are really, of their representatives, how many of them are really thinking about the fact that we need to provide an economic environment? I want to say to those persons listening that this law, insofar as it will make it possible to limit criminal activity, to that it will make an impact on the economic landscape. It will be one thin layer, I granted, in that security blanket that we need for our tourism industry. But more importantly, it will protect our citizens, protect the children, protect while we work and collaborate, hopefully, to get, you know, and we're in a place where our legal landscape supports the economic activities that we hope to stimulate. And I believe that this law, this piece of legislation, does that. So, Mr. Speaker, is to say that again, to commend the efforts of the Youth Parliament, to say that I believe the consultation process demonstrates that if we do it and follow that process the right way, and we have now an example of where it was done well, fairly well, based on what the AG personally contributed to the process and the leadership that came from the police, the Royal Angola Police Force in that regard as well. And I think that should be a template for each of our quiet representatives to really stand to that and embrace that, so that we demonstrate more commitment to our people in advancing, you know, issues that concern them greatly, but especially in this environment where our people are suffering and almost devoid of hope as to what the future really is going to bring, Mr. Speaker. And I want to assure those listening, as I said before, Mr. Speaker, that there is hope. And this law is one step in that process. Thank you, Mr. Speaker.
Thank you very much. Is there any other contributions?
Thank you very much, Mr. Speaker. Mr. Speaker, I stand in full support of this police amendment bill. And I couldn't agree with the Honorable Attorney General more. When he mentioned safer gun training, not only for the police, and you're collecting these samples in an aseptic environment, but they're going to contaminate the samples is good. process in which it is collected. Of course, Mr. Speaker, the interpretation of the fingerprint question, and I'm sure you have a question at the top there, realize that all of these things are very important. The accuracy of the measurements used, Mr. Speaker, and a number of other things to help, not only to deter criminals, Mr. Speaker, but to bring perpetrators to justice, to let them know that law enforcement will be equipped with the necessary training and necessary tools in order to assist them, not only in bringing perpetrators to justice, but also to help deter crime. Mr. Speaker, it is always good when we involve our young people in our development. And it is very interesting, it is very important for young people to pay attention to what takes place in this honorable house. And to bring each and every one of us, in terms of content, Mr. Speaker, and in terms of relevance. And I hope you're listening. And I don't want the young people to listen to answers alone, Mr. Speaker. I want them to listen to questions, and to the content of the questions. Our young people, I have faith, I know they can discern. The questions are answered, and the questions are live, and the questions are relevant. Have that confidence in them, Mr. Speaker. And Mr. Speaker, I mentioned this morning in one of the answers, experience is a great teacher, Mr. Speaker. And I'm sure that the young parliamentarians and the young people of Angola in general would realize that the government consists of 4 ministers. The Constitution allows the 4 ministers. The 4 ministers sit in executive council. And I'm sure that the young people would realize that the Attorney General is also a member of the executive. Gives us legal advice. We spoke about it this morning. So my colleagues on this side of the aisle decide one way or another not to contribute to a particular law that's here. It's simply that we're not ready on and Mr. Speaker, as I said, I understand the situation that the member for Allentown and me have in opposition. Is it? Because I too, Mr. Speaker, had a very long stint on that side of the aisle. So I understand politically. I am not so sure the member for Allentown understands takes place. How the government. So, time will tell. It's always good to keep open eye. You never know. But I just want our young people to know, Mr. Speaker, that content and relevance with respect to questions. And they've been following us. I know they've been following us. Been following all our presentations. And they will be able to decide for themselves. But again, to come back to this police amendment, I'm totally in favor, Mr. Speaker, having a 15 law enforcement to require tools and legislation and the law to back up in order to be able to help solves the crime and prevents these criminal activities. I am equally supportive of the fact and remorseful adequately trained business in the processes which will afford them the opportunity to stand in the court of law, really and truly, defend against the processes, the samples, and so on that they have collected. Support it wholeheartedly. This amendment to the police. Thank you.
Thank you. Any other contribution? If not, we'll go back to that.
Mr. Speaker, I'm very grateful. Again, I only say that I offer my gratitude, as I did with the Witness Protection Act, to all those who worked very hard to collaborate, enter the dialogue and be part of the consultation process. These bills don't happen overnight, they don't happen without hard work, so I'm extremely grateful to all those members of the House sitting here, but all those others that have been mentioned for their part in this.
Thank you. There's a move and second to the bill entitled Angola Police Amendment Bill Chapter 16. In order to set up that. Those in favor?
Aye.
Those against? Ayes have it. The call of the clerk will read the bill and second that.
Angola Police Amendment Bill 2016, second reading. A bill to amend the Angola Police Act, revised statutes of Angola, Chapter 870, to give the police power to take measurements, photographs, fingerprint inspections, and non-independent samples on arrest.
Thank you. The rule 54 of the Laws of Assembly Procedure, this bill now stands before a committee of the whole Assembly to consider clause by clause. Assembly Committee.
Clauses 1 through 7.
Question by clauses 1 through 7. The amendment be approved as subdivision. Those in favor?
Aye.
Those against? Ayes have it.
The preamble.
Questions of the preamble? Be approved. Stand parliament to be those in favor?
Aye.
Those against? Ayes have it.
Title.
Questions of the title be approved. Stand parliament to be those in favor?
Aye.
Those against? Ayes have it.
Enacting clause.
Question is that the enacting clause be approved. Stand parliament to be those in favor?
Aye.
Those against? Ayes have it. Now we will now resume it today.
Mr. Speaker, honourable members, I beg to report that the title, the Anguilla Police Amendment Act 2016, has passed through committee without amendments and is ready for a third reading.
The Angola Police Amendment Bill 2016, third reading.
I move that a bill entitled the Anguilla Police Amendment Bill 2016 be read a third time and passed.
You have a second?
Second that, Mr. Speaker.
We have a move for item not. There's a move and seconded that the bill shall be entitled the Angola Police Amendment Bill 2016 be now read a third time and passed. Those in favor?
Aye.
Those against? Ayes have it. I call upon the clerk to read the bill. Okay.
Angola Police Amendment Bill 2016, third reading. A bill to amend the Angola Police Act, revised statutes of Angola, Chapter 870, to give the police power to take measurements, photographs, fingerprint impressions and non-internet samples on arrest.
Thank you. Bill read a third time and passed.
Scheme of arrangement, High Code and Plea Code Bill 2016, third reading.
I'll take that as an amendment to it being the second.
Second reading.
I'm grateful. I move that the bill shortly entitled Scheme of Arrangement, BICO and CLICO Act 2016 be read a second time. Let me explain as briefly as I can what this bill is all about. At the back of every bill we have objects and reasons, which is a way of communicating to the general public, to non-lawyers, what the purpose of a bill is all about. It's helpful sometimes to rely upon that and try to summarise the contents. The purpose of the bill is to provide a framework to aid in the resolution of the insolvency of British American insurance company that I do apologise, otherwise known by its acronym BICO, B-A-I-C-O, and CLICO International Life Insurance Company Limited, again I called it CLICO, by means of a scheme of arrangement. So what this really is about aiding the resolution of these two insolvent companies. They've had interests across various jurisdictions, and there's been a lot of litigation across ECSE member, the states and regionally. And this was a bill, first proposed as a model bill by the OECS in order to assist in the cross-regional resolution of these two companies. So that's really what it's all about. It's enabling the Eastern Caribbean Supreme Court and all the member territories to deal with the complex nature of the insolvency of these two companies. There are a series of definitions that begin the bill, but I won't go through many of them, other than it sets out the EC states or territories, meaning those signatories, to the Eastern Caribbean Supreme Court. So we know them, apart from Anguilla. I'm sure everyone else knows the other 7, Antigua and Barbuda, Commonwealth of Dominica, Grenada, St. Christopher and Nevis, St. Lucia, St. Vincent and the Grenadines, and Montserrat. So those are the other EC territories or states, and they're all parties to the Eastern Caribbean Supreme Court. The Home Court means in the case of BICO, the Supreme Court of Bahamas, and in the case of CLICO, the Supreme Court of Barbados. So those are some of the definitions to give you an idea of what's going on. Clause 2 of the bill is about the power to compromise with creditors. And what Clause 2 it speaks about a scheme of arrangement, and that's what we've earlier heard of. So the scheme of arrangement is the way of trying to resolve these insolvent companies. So Clause 2 speaks to the situation where a scheme of arrangement is proposed in the role of the court. So before summoning a meeting, the court must be satisfied that the conditions spelled out in subclause 2 are satisfied. And then where a majority number representing at least 3/4 of the value of the creditors or class of creditors of the company present voting either in person or by proxy at the meeting agree to the scheme of arrangement, then the scheme of arrangement shall, where sanctioned by the court, be binding on all the creditors or classes of creditors wherever they're located and on the company. So it's a way of giving the courts a way of sanctioning and making a vote to enter the scheme of arrangement binding. Under Clause 2, the judicial manager must, within 7 days of the court making a sanction order, provide a copy of that order to each other officer. A sanction order is means in the case of a scheme of arrangement proposed under Section 2, it means an order made by the court under Section 3. So that's the order, it's making a sanction order, it's effectively sanctioning, approving this scheme of arrangement. And the scheme of arrangement becomes binding on all the creditors of the company, wherever located, and on the company when the conditions specified in subclause 5 are satisfied. I won't read all of those out. So that's how to compromise with creditors.
Under Clause 3, the scheme of arrangement originating outside Anguilla, Clause 3 addresses the procedural law requirements that must be satisfied when the scheme of arrangement originates outside Anguilla, and again it becomes binding when the conditions specified in subclause 6 is satisfied. And then Clause 4 of the bill deals with the information as to compromise with creditors, and it makes mandatory that where a meeting is summoned under Section 2, which I've already talked about, every notice summoning a meeting must include a statement explaining the effect of the proposed scheme of arrangement, state any material interest of any person connected with its promotion, and effect thereon insofar as it's different from the effect on the like interest of the other creditors. And again, a provision is made in respect of the statement reaching the creditors when the notice is given by advertisement. Clause 5 deals with sub-meetings, and that makes provisions for sub-meetings to be held on multiple locations, which are deemed to be a single meeting. It further states that any procedural error or inconsistency with respect to any sub-meeting should not render the meeting invalid unless the court or the Home Court ordered the meeting orders otherwise. Then under Clause 6, there's the priority of distribution of assets, and this gives insurance claims first priority on the assets of FICO, ranking above all unsecured creditors after costs and expenses of the judicial management or the subsequent liquidation of FICO have been satisfied. And in respect of PICO, the priority of claims of creditors in any proposed scheme of arrangement shall be in accordance with the laws of Barbados. And then Clause 7 deals with the power to make regulations to give effect to the Act. So that's the bill in a nutshell, as it were. I commend it to the House.
Thank you to the Representative. Speaker Baker, second by the member for Raleigh South. And I will try to lead on the merits and procedures of this bill.
Thank you, Mr. Speaker. Mr. Speaker, this bill highlights the culmination of a process which has been ongoing since as far back as 2008, reform, when British American Insurance Company, company fell into very serious insolvency difficulties. As a result, a number of persons throughout the region were affected. Mr. Speaker, somewhere in the region of $800 billion would have left the Caribbean as a result of investments made by these agencies in North America. And with the crisis that took place, the housing crisis that took place there, the investments by Tico and Baco fell into decline. As a result, they were able to meet their commitments to creditors and also persons who were taking annuities with these agencies. As you recall, the activity of British American Insurance included Angola, as well as Tico. There were some instances where certain institutions and other agencies had invested in some of the instruments that they sold throughout the region. Angola was not affected to the extent of other territories, but certainly, I know, in light of a number of agencies in Angola, which would have made investments in British American Insurance instruments, and they all are now required to be paid off. Obviously, the payoff will be based on cents and the dollar. It certainly brings to mind a situation that now exists in Angola. The insolvency of Caribbean Commercial Bank, National Bank of Angola. those two institutions fell into hard times as a result of similar situations in the world, global recession, the inability for a number of customers to meet their commitments and obligations to resolve banks and unable to meet their commitments. Mr. Speaker, the government of Angola stepped up to take care of its domestic customers. We thought it was most important. Because those domestic customers are taxpayers in Angola and are part of the Angolan economy. Just like the American government would have bailed a number of the savings and loan banks and other large banks within the United States in the interest of the citizens, the government of Angola came to the table. The case of Baco and Clico. Baco and Clico are two companies, headquarters French. The case of Baco, I think it's Barbados, headquarters in Barbados. And the case of Clico, headquarters in the Bahamas. Sorry, the other way around. Baco in the Bahamas, Clico in the Bahamas, in Barbados. They, Mr. Speaker, have responded to these issues. A number of regional governments came to the table to assist in some way by trying to stabilize those companies. The case of Trinidad and Tobago, as well as Barbados. Eventually, Mr. Speaker, the situation continued to deteriorate, as in every case where there is a judicial manager, there is an administrator or a liquidator. The process must take its course. And noted in the presentation that the Honorable Attorney General made, and I think it's worth noting that in section 6, clause 6, regarding distribution of assets, it should be pointed out that although the claims of the insurees, insurance claims, are the first priority on whatever assets that Baco has, this American insurance company has, that it ranks like it above all unsecured creditors after the cost and expenses of the judicial management or the subsequent liquidation of Baco and its satisfied. So whatever funds have been secured for the payment of the creditors, the only persons whose entire interests are secured are the judicial managers, the liquidators, and obviously the lawyers who they engage. I said that to say this, Mr. Speaker. In the case of the local institutions, the banks, Capital Commercial Bank and National Bank of Angola, the government of Angola came in immediately to ensure that, as far as the domestic banks are concerned, that we ensured the deposits and the claims of domestic deposits 100%. And did not lead to a process of liquidation that would have caused Angolans to get sense down. Of course, in the case of the offshore subsidiaries, here becomes an opportunity for an administrator to be appointed, a number of legal persons to get involved and free. At the end of the day, those legal persons will be paid, the administrator will be paid, customers who at that point will not have any further support outside of the claims they made on the parent bank or any other institution will stand in line to those persons. Some have to pay ahead of time to receive whatever comes of the liquidation process, which inevitably will be sent to the down. Mr. Speaker, the issue of Biko and Tico have plagued our region for a very long time. And in fact, the Eastern Caribbean Central Bank got involved in the frame to assist with other agencies to bring in some closure to this process. It appears that the entire liquidation process is resolved in most of the insurance claims being very marginally addressed. A number of persons will lose several millions of dollars as a result of this process. It again points to the fact, Mr. Speaker, that a number of institutions, insurance companies, banks, and other agencies in the region dealing with financial institutions, not only here but in the United States and the region, calls for regulation. We need to put in place strong regulatory agencies which have the teeth and the wherewithal to regulate these institutions. The insurance sector was not properly regulated in our region. That is why the situation occurred with Biko and Tico. In the banking sector, there is also need for stronger regulation in the choice of directors, in the standards and guidelines and principles for banking, ensure that decisions are not made that will affect the interests of the partners in a negative way. Mr. Speaker, there are lessons to be learned. And this bill before the House is to basically salvage equity for the insurees who would have claims against these agencies. And we as a part of the regional process, Mr. Speaker, are being involved in putting in place legislation that is harmonious to the region to affect this process. Mr. Speaker, it is critical that it be done not for Anglo alone, but for our brothers and sisters around the region who have been directly affected by this fiasco that occurred in the insurance sector. I would like to commend this bill to the House. Thank you very much, Mr. Speaker.
Thank you. We have any more contributions?
Mr. Speaker,
Member Fernando.
thank you, Speaker. I just wanted to recognize that, in fact, this legislation is really in Anguilla. It's late coming. It's already been, put into law in several of the other OECS jurisdictions, and it's been. I understand that the Chief Minister, while he appears anxious to implement, what is desirable in the region, and I think in this case it's a good thing. However, I'm a little bit concerned that those persons in Anguilla who might have invested in policies, that they would not have been given an opportunity. I mean, this kind of arrangement could have been put before this honorable House as early as it did in some other jurisdictions, as early as February and March. So it's been long time, and still good to be here. And I think, Mr. Speaker, the fact that, I mean, it cannot be celebrated at all that we in Anguilla are where we are today by virtue of the arrangements that have been put in place by any of our financial institutions or by our government in relation to the banking resolution or otherwise. The Peacock British American fiasco, it was a part of that. It's viewed as an important part of our destructive experience of how our financial institutions were allowed to operate in a place where there wasn't the proper regulation, there wasn't the proper thinking. We are coming here because in relation to the scheme of arrangement, because really important provisions were not addressed in the legal landscape. So that, for instance, it allows for assets to be transferred to different entities, allows for the court to confirm certain decisions, because our legislative landscape didn't include provision for that kind of situation. So it's the worst possible thing. And for investors looking towards Anguilla, looking towards the region, but looking to Anguilla particularly, there is nothing to celebrate in the fact that just like the policyholders here, our investors, our depositors, who put in some cases their life savings into our indigenous banks, that their predicament, just like the policyholders' predicament in this case, been totally disregarded in a callous, ugly way that's likely, Mr. Speaker, not to be shoved under the carpet or rear its head. Again, it's going to be dealt with in the courts. Going to be dealt with in the courts. And I think, Mr. Speaker, the Anguillan people, not just the policyholders or any of those who invested in the offshore, deposited their funds in the offshore entities, they are the ones who we need to give support to and understand their position, not to justify it. Mr. Speaker, in all the countries, starting with Dominica, I believe, really early this year, there's been a lot of discussion about it. And the Chief Minister made a very honorable Chief Minister when he said that we need regulation in place. What we also need to be doing, Mr. Speaker, is projecting and leading Anguilla in such a way that we can salvage right now our reputation with those offshore investors, that we can salvage our reputation with those institutional investors who've suffered by virtue of the software we're describing here now. We have to salvage our reputation because without it, Mr. Speaker, and without any creative thought as to how we're going to get to the next stage of development, get out of this slump that we're currently experiencing, we're not in a good place. So, Mr. Speaker, I would have liked, because our Honorable Chief Minister, this is a piece of legislation that the ECCU developed, harmonious, as you said, but I would have hoped that our Chief Minister, not conflicted by his position in the region, in that role, would have been absolutely able to move swiftly to advocate certain insolvency legislation that might have yielded opportunity for our people. That is the kind of creative opportunity that exists in this scenario. But we're here to demonstrate that. We might be in a position to put good insolvency legislation and lead the region in that regard, showing that we're not just in place to maintain a status quo, but we're prepared to be creative, we're prepared to be purposeful with a view to transforming our economies and not allowing for the slumps that's been prolonged in this region, particularly in Angola at the moment. Thank you, Mr. Speaker.
Thank you. Any other contributions? If not, we move on, I respond.
Speaker, I have nothing to add to the contributions that we've had.
Yeah, not to make as well.
Yes, sorry. I have nothing to add. Thank you very much.
Agreed. That's been moved and seconded that the bill shortly entitled Scheme of Arrangements for Triaco and FICO Act 2016 be now read and seconded by the those in favor. Aye. Those against? The ayes have it. And call the bill as seconded.
Scheme of arrangement by Puerto Rico Bill 2016, second reading. A bill to provide a framework to aid in the resolution of the insolvency of British American Insurance Company Limited and Quico International Life Insurance Company Limited by means of a scheme of arrangement.
On the rule of the laws for separate procedures, before that, on the rule 54 of separate procedures, this is now started before the committee. Before Assembly to consider it clause by clause. Assembly committee.
Clauses 1 through 8.
Consider clauses 1 through 8. They approve as substituted. Those in favor? Aye. Those against? The ayes have it.
Title.
Consider that the title be approved as substituted. Those in favor? Aye. Those against? The ayes have it.
Preamble.
Question is that the preamble be approved as substituted. Those in favor? Aye. Those against? The ayes have it.
Enacting clause.
Question is that the enacting clause be approved as substituted. Those in favor? Aye. Those against? Ayes have it. The Assembly will now resume sitting.
Mr. Speaker, honourable members of the House, I beg to report that the bill entitled the Scheme of Arrangement FICO and Quico Act 2016 was passed through committee without amendments and was laid to the third.
Scheme of arrangement by and Quico Bill 2016, third reading.
I move that a bill entitled Scheme of Arrangement FICO and Quico Act 2016 be read a third time and passed.
You have a second? Yes.
Make a second, Mr. Speaker.
Yes. We move and seconded, and I will shortly title the scheme of arrangements for Bayako and Clico. We read that the time and passed. Those in favor?
Aye.
Those against? Ayes have it. I call upon the clerk to read the bill. Thank you.
Scheme of arrangement by Equal Clico Bill 2016, third reading. A bill to provide a framework to aid in the resolution of the insolvency of British American Insurance Company Limited and Clico International Life Insurance Company Limited by a means of a scheme of arrangement.
Bill read a third time and passed.
Immigration and Passport Amendment Bill 2016, first reading.
Mr. Speaker, I beg to move that the Immigration and Passport Amendment Bill 2016 be given its first reading.
Immigration and Passport Amendment Bill 2016, first reading. A bill to waive immigration fees in respect of certain persons and for matters connected therewith. Control of Employment Amendment Bill 2016, first reading.
Mr. Speaker, I beg to move that the Control of Employment Amendment Bill 2016 be given its first reading.
Control of Employment Amendment Bill 2016, first reading. A bill to exempt non-belonging grandchildren. A bill to exempt non-belonging grandchildren of belongers born in Anguilla from the need to have work permits and for matters connected therewith.
Thank you.
Adjournment.
Mr. Speaker, I make a move that this House stands adjourned until tomorrow, Wednesday, 27th July. 10 o'clock.
Mr. Speaker, I second.
Sorry, Mr. Speaker. Do we have to do that?
We get together. I didn't get it.
Do we have to do that?
No, I wasn't aware.
I'm sorry.
Yes, you
I'm happy with it.
Okay, that's no problem.
She's the bill for interest.
Okay, so tomorrow morning, you said?
Yeah, 10 o'clock.
Do you have a second?
Yes, we did.
I second the motion, Mr. Speaker.
Seconded by member of the
We
You
can
moved
read
and
it.
seconded? You saying something?
So, I say there'll be no meeting for the rest of August. No meeting.
No meeting in August? Okay. You moved and seconded at this house. We have job at tomorrow morning at 10 o'clock. Those in favor?
Aye.